Good evening once again, and welcome to my YouTube channel. And good morning also, or good day, depending on whichever part of the world you are watching us. I will appeal to you to please subscribe to this YouTube channel and show some love by sharing the content of this YouTube channel. So welcome again. Today we'll be looking at contract of employment and the parties to it with reference to the Nigeria environment. So when we talk about employment, we are talking about people who are considered to be doing work to be doing work for a pay or for profit during a specific period of time. It could be weekly, it could be monthly, depending on what the agreement with the organization is. So, for that individual will be an employee of that particular organization who has entered into the organization through contract of employment. Um, then the employee must focus on how he or she is being treated when it comes to contract of employment, the job security, career growth and involvement and everything. The employer on his own part is that authority that employs the employee and pays him for the job or the labor that he's being offered. So it is expected that the employer must be competent, must be committed to the contract of employment. So an employer is that kind of has the legal liability to make sure that the place where the employee is working is conducive enough. He must also maintain labor laws and make sure that it does not fall short of the law in handling any action that pertains to the employee that is under his employment. So when it comes to contract of employment, we are talking about those written documents, which can also be oral, that is given to an employee at the beginning of his employment offer. He either accepts it or he will reject it depending on whatsoever it is that is in the contract of employment. So it is a legal binding agreement between the employer and the employee. It is expected to be specific. It is expected to be to cover the rights of the employees and employer. It is expected to have the responsibilities and the duties of both the employer and the employee, and it is also expected to have an offer and acceptance and benefit that is accrued to both parties in that contract of employment. So in writing that offer, we should have a job title. We should have the date that the person that is supposed to start the job that will start. We should also state the salary that the person is supposed to have, the date of the payment when the person should be paid, the hours of work that the person should put into that particular job. Is it going to be 8 hours, 12 hours, 16 hours, whatever is in agreement? And then if there are other fixed term agreements or disciplinary agreement, whatever it is that need to be there is expected to be in that particular contract of employment. And this contract of employment have some types. The first one is what we call the full-time or the permanent employment contract, where the employee is a permanent staff of that particular organization. He is on full-time. Is expected to put 38 hours or 40 hours per week. An average of 38 hours per week is expected of him if he's on a full-time, if he's a full-time employee of the particular organization. Or for the person that is on a part-time employment contract, he's not expected to put as much. Maybe the part-time is coming and do and go away, or maybe coming in the evening, whichever the agreement they have. Then you also have the casuals or the 0-hour employment contract, where these people have little or no employment contract. Is just like what we have in some organizations in our nation, where you in the morning people queue at the gates, people will now say okay, come in, you work, by the evening they envelope the money and give you. So there is nothing binding between you and those people. You just come in, and then sometimes it could be some construction company. You stand by the roadside when they're going to the site. They will just ask the person to, you volunteer yourself to join them. You get there, you work for the day, and then when coming back, they return you to the bus stop where they got you. You will come down, and the person will come down and then go back home, and the cycle continues, and then that is it. Or you could also be independent contractors employment also, where the person is an independent contractor coming to do work for the person for that period of time, and once that job finishes, the person goes away. So these are some of the types of contract of employment that is visible in the nation Nigeria. The contract of employment that you will receive will be based on your employment status that you have with that particular organization, and is to be agreed between the employer and the employee to make sure that everybody is happy with the terms of employment of that particular organization. Because if you don't do it that way, the party that is not happy may not give the organization the best of the best that they need. And so there are some of the roles that this contract of employment plays in our lives as a nation and as individuals. A well-drafted employment contract, you find out that it will give you clear set objections or obligations about what, or objective of what is expected of you, or expectations of you as an employee from your employer, of which if you fail as an employee to meet those obligations and expectations, some penalties may be melted on the person. And it also provides the employer also with the flexibility in the face of challenging business needs to be able to make some adjustments, and that's why you see some adjustments. They will say, okay, this one we are forgoing it this time, when business improves we will give you back, and all those terms. So you could also be there. Another thing that is very, very important to the contract of employment is that it outlines every expectation of both parties. It gives the employer, the employee, their responsibilities and their duties towards each other. It protects both parties. If one part did not meet their obligations. So if the other part did not meet, let's say it's an employee that did not meet his obligation, it protects you to say you are not going to get your rewards. And then if the other person that is the employer fails, it protects you to say I've done my own part, and so you don't want to give me, I can take legal action against such an employer. So your contract is made up of three basic parts: an offer, an acceptance, and a consideration. The offer and acceptance are what the purpose of the agreement is between the parties. Essentially, in a contract of employment, everything you need to know covers the contract basic. What is the basic of the contract? The contract clarification must also be there. The offer must also be there. The acceptance must also be there. The meeting of the minds of the two parties will be there. Other consideration, capacities and legalities must be there in the contract of employment, meaning that the contract of employment, according to our Labour Act Code 198 of the law of the Federation, means any agreement, whether written, oral, express, or implied, whereby one person agrees to employ another as a worker, another person agrees to serve the other as a worker. So in our Labour Act, there must be somebody who is agreeing that I'm going to serve. There must be somebody who is agreeing to employ some other person to serve in that particular organization. So we can basically say it's a binding agreement of employment between the employer and the employee, and that there must be two parties to it, and those two parties must be the employer and the employee. Those are the two basic parties to the contract of employment. Just like section 7 of the contract of employment stated that if you have given somebody this job, it's expected that if the person, you have given the person the contract of employment, the person has signed it, that after some time it's expected that when you give him that contract of employment, you must give him the name of the employer. You must give him a place and a date where he's supposed to report. You must give him the nature of the engagement you want him to have. You must also give him a fixed and expiring date in case he's not on a permanent basis. You must also give him length of notice of termination in case you want to terminate his appointment. The wage that he has to be paid, the method of him calculating that wage must be very, very obvious for the person to know. The period of payment, is that at the beginning of the month, is that at the middle of the month, is that at the end of the month, must be specified. If there are working days that are supposed to be work holidays, the person need to be given those work holidays or holiday pay, as the case may be. Also, if there are pay for injuries and any other special conditions that need to be known, you are also to provide it under the contract of employment based on that section 7. Under the section 9 of it talks about that the contract of employment cannot be binding on worker's family or dependent unless you express it in that contract. You cannot say I did not meet my obligation in terms of job, and so you are going to carry my brother to come and get him to do the job, except we have expressly expressed it in the contract of employment to say this is it. And no person under the age of 16 also, according to the labor law, should be allowed to enter this contract of employment except under the case of apprenticeship. These are some of the things that the contract of employment is supposed to expressly express. Look at your age and know that no, I don't want trouble, you have to go. Payment of wages of workers shall not exceed the monthly intervals unless government approves otherwise, so that the workers will get their wages on time, not that salaries will be owed 23 months, 12 months, 6 months, and all the months. And that the workers also are bound to answer for that no worker is bound to answer for the debt, default, or miscarriage of any other person. Meaning that if 3 of us are working and somebody spoils something, you cannot say because 3 of us are in that group I must pay. I must contribute for the payment. It's the person that spoiled those, or the people that spoiled those things, that will be paid. You can't say because we are there I must be answerable to it if I'm not part of it. So the contract of our employment also makes it that your condition of employment shall not stop you from joining labor unions. So those are the things. We cannot stop you from being a member of labor union. And then your dismissal also shall not be without any prejudice. Those are the things that the contract of employment is supposed to specify for you. Under section 10 of the same contract of employment, under the Labor Act, it said that you find out that the law is saying that under the contract of employment, it shall be specifically stated. If you want to transfer people, you specify it there so that the person doesn't go holding the law that says no worker shall be transferred from one place to another without the person's consent. You can't just wake up in the morning and ask somebody to start moving without the person's consent. If it must happen, that worker must give his consent freely for him to move. But if you know that you can transfer it, please put it in the contract of employment so that the person will know this is what it is. So anything that has to do with mutual agreement, collective bargaining, and other issues must be expressly stated in the contract of employment. If the person is traveling, you must write it under the contract of employment. Maybe for you to go outside Lagos, you must get the permission of either. For me as a lecturer, if I'm going outside Lagos, my VC must know. If I'm within Lagos and I'm going outside the school, my HOD must know, my dean, there are specific limits, just like the specific amount that can be spent. So there are specific limits. Those things are the things that must enter into the contract of employment, so the person knows that I cannot be found in Benin when I'm supposed to. These are the person I'm supposed to report to. You must specify all those things that you need to be done into your contract of employment, so that the worker will know these are my duties, these are my responsibilities. You also will know this is your duty, this is your responsibility, and you apply it as when due. So make sure that nobody is on the path of unlawfulness in terms of anything that has to do with work, leave, holidays, pay, or whatsoever it is. So for the employer, he has some rights that is given to him by law that must be made known to the person that is being employed under the contract of employment. He has the right to direct the business as an employer. He has the right to make profit. and then they return such profit to the shareholders. He has the right to hire and fire. He has the right also to promote, demote, and transfer. He has the right to discipline you when you have gone wrong. He has the right to lay down policies that will guide your rules and regulation. He has the right to establish the working hours. To reorganize the organization is the right of the employer, and then to expand and grow is also the right of the employer. These are some of the things that you need to put together so that the employee does not go beyond his boundary. On the side of the on the side of the on the side of the employer also, he has the right to pay wages, to treat sicknesses for the people under his employment, especially if it is the e-health that was gotten through jobs that were assigned to the person. So you also have the right to a kind of breach any contracts that has been there, but in it all he must make some payments in case he decides to lay off the person, as at not as when he likes or whatever thing he wants to do. So his duty is to make sure that he has competent staff that will work, and that they all a kind of comply with the statutory provisions of the contract of employment. For the employees who are on this side that doesn't have the organization that are working for their pay, you have the right to be law abiding. You must obey all lawful and reasonable orders. Is your right that when they send you, because we're talking about the parties to this contract of employment. So the fact that you're a party means that you have the right to obey all lawful and unreasonable orders. If the order is not lawful and unreasonable, you are not expected to obey it. You should also not engage in any act that is contrary to or detrimental to your employer's interest. Whatever will affect the interest of your employer, either by trying to steal customer or steal product or patent, whatever it is that is so that you are not expected to do it. You are also not expected to cause injury to his property or his person as your employer. You as employee, you are not expected to collect bribe or any secret commission from anybody in any way at all. And when somebody is making such gestures to you, you're supposed to report back to your employer to say, look at what this person is doing, because you are not supposed to do that. You are supposed to willingly do your work without anybody pushing you. You are supposed to be honest and cooperate with the employer. Once he or she has reasonable instruction for you to do, you are supposed to cooperate with them and do it. As an employee, you are not also supposed to engage in competitive activities with your employer. Maybe trying to use his time to go and do your own business, try to use his property to do your own business. That's competition to him. It will harm him. You're not supposed to do that. You are supposed to account for every benefit that has come through the course of your employment. In the course of the employment, there are benefits made. You're supposed to account for it, and you are not expected to delegate your authority without the consent of the employer. Somebody employed you can't go and bring somebody from outside to say, because I'm a lecturer, I'm not going to be around. Okay, you come from my brother is so person, so come and stand in for me in the school. No. For you to be able to do that, either you must get the consent of your employer to say, I'm not going to be around, but my brother also is a lecturer somewhere, he's in my house, can he come and teach for me? You can't just go say, because I am a lecturer, you're a lecturer, go and stand in for you. You must have the consent of the employer. You must take care of your job and do it diligently, and you must not divulge confidential information or useful information about business strategy, marketing strategy, industry strategy, or production formula to anybody that is not your employer. It is not right. So the employer have the right, if you in any way fall short of these things that I've just expressed, he has the right to discipline you, but he doesn't have the right to discriminate in any form. He doesn't have the right not to pay minimum wage. He doesn't have right to go beyond the working hours without your consent. He doesn't have the right to take away your holidays except you give the consent to it. He cannot give you unfair dismissal. He cannot put you to redundancy without a just for no reason. And every other thing that doesn't have rights to do towards you, he has no right to do it. So it is for us as under contract of employment, for us to do better, we need to just make sure that we follow these particular rules of making sure that all these things are written down, then offer it to whoever you want to employ. Let the person go through it and see if it fits him. Let the person agree. But remember, you on the employee side, once you have agreed that this is also amount, you agree that you collect it, this is your working hour, you have agreed, this is how what you will do, your great punishment, you have agreed. You cannot come back to say I do not know, because it is an agreement. An agreement is binding. Thank you for having me today. See you in the next edition of our discussion, and God bless you.